So I was just told that SpaceX is actually going to launch 2 human beings into space in about half an hour. Did anybody know that was happening today? I did not.
I love this real life polling.
All right. Good afternoon, everyone. It's now 1:01 p.m., so I'm going to begin the program. Welcome to the Bankruptcy 101 Primer on Reorganization, Liquidation, and Creditor Issues in a Post-COVID World program brought to you by the Orange County Bankruptcy Forum and the Orange County Asian American Bar Association. This program was designed primarily for non-bankruptcy attorneys so that they can learn something about bankruptcy, but looking at the list of participants, I see a lot of experienced bankruptcy attorneys, and some judges are listening in to this program as well. My name is Scott Yoon. I'm a United States bankruptcy judge in the Central District of California. I am based out in Riverside. Before I introduce the panel members, I wanted to give you some basic information. As you may have already seen, to make this program more interactive, we have some polling questions for you. One has already been up while you're waiting for the program to begin. We wanted to start with this poll because the panel members wanted to get a little bit of an idea about who's participating in this program, how much bankruptcy experience they have. We have also enabled the chat function. Some of you are already using it. This is a way where you can ask questions for the panel members. I, as a moderator, will be looking at the chat questions, and time permitting, I will try to incorporate some of the questions that are asked in the chat function to the panel members as they present their part of the program. Before I introduce the panel members, I also want to remind you of one other thing. This program is being recorded, both the video and the audio. And just so you know, I think this also saves whatever people wrote down in the chat box. So just so you know, whatever you write down in the chat box is going to be part of your permanent record. So beware. So before we begin, let me introduce you to our panel members. We have a great panel for you today. First panel member is Linda Bowie. She's a partner of Showman, Bastian, Freeman, and Bowie. She has been a long-time chapter panel trustee in our district. She has also been a former president of Orange County Asian American Bar Association, so many of you may already know her through that organization. Our second panel member is Aaron Malo. He is a partner of Shepard Mullins Orange County office. He's going to provide the group with sort of the creditor lender perspective of the bankruptcy issues. And our final member is Lele Wang Ekfa. She's a partner of Smiley Wang Ekfa. She is sort of our Chapter 11 debtor expert on the bankruptcy issues for this panel, and she will be covering some of those issues as well. Now, my job as a moderator is relatively easy. I get to introduce the panelists. I'm going to give you some basic background information about what we're going to be discussing. And then just like what I do in my day job as a judge, I turn it over to the attorneys who then have the hard work of actually doing the presentation. So if we can go to slide 2. So hopefully everyone can see this. The areas that we're going to be covering are on the PowerPoint presentation, hopefully that everyone can see. General principle bankruptcy, I'm going to cover shortly, key bankruptcy terms and concepts. Then we're going to give you a basic overview of the different types of bankruptcy cases that we usually see, chapters 7, 13, and 11s. Then we get into the litigation aspect of coming to the bankruptcy court. For many non-bankruptcy attorneys, that's probably how you're going to be interacting with the bankruptcy court. And finally, we're going to cover the area where you may be involved in representing a party that has to deal with a company that ends up in bankruptcy. So the next slide, general principles of bankruptcy. So these three basic concepts are what governs the bankruptcy court and bankruptcy law. One is a fresh start for the honest but unfortunate debtor. More often than not, when I see non-bankruptcy attorneys come to the bankruptcy court, they view the bankruptcy process extremely unfair, that debtors get to spend all this money, not pay anything, and get a discharge. Well, that's how things work. That's the principal reason why the bankruptcy code and the bankruptcy court exists. The second overall fundamental principle of bankruptcy is we want an orderly liquidation process or reorganization process. We do not want to create a system where outside of bankruptcy, the party who gets to the court first to sue a debtor and get a judgment steps ahead of everyone else. So we want an orderly process, a collective process, rather than who gets to court first and gets a judgment. And the final big picture principle of bankruptcy is equal treatment of similarly situated creditors, where all unsecured creditors are treated the same. All priority creditors, depending on which level of priority you fall in, are treated the same. So these are the three fundamental sort of principles of bankruptcy. And Now, if we can get to the next slide, slide 4. So what you see on the screen now are some of the basic terms that we're going to be hearing about throughout this program. And just you have the materials in front of you. I'm not going to get into each item specifically, since I have 3 great panel members who are going to do that for you. So at this point, I'm going to turn this over to Lele, who is going to tell you a little bit about debtor versus debtor in possession.
Hi, everybody. Good to be here today. So one of the terms that you'll see or hear us bankruptcy attorneys use quite frequently is the term debtor. The debtor is basically the person that has either filed for bankruptcy or has been involuntarily placed into bankruptcy. If they're in an involuntary bankruptcy and they have not consented to the bankruptcy, sometimes you will also hear that person being referred to as the alleged debtor. But when in a Chapter 11 case where there's a Chapter 11 bankruptcy petition filed, the debtor will often be referred to as a debtor in possession. And that's somebody that has all the powers and duties and rights of a trustee. So in a Chapter 11, when the debtor is in possession, that person has all of the rights and powers of a trustee. Now, if a trustee eventually gets appointed in a Chapter 11, then that person is no longer a debtor in possession, and they go back to being either the debtor out of possession or just the debtor. So just some terms to keep in mind as we go through this. Next slide.
Hello, everyone. Thank you, Judge Hume, for the intro. And let me begin by wishing everyone well. This is fun. I've sat through many webinars, and now I have an opportunity to do one. So I'm excited, but it's very different than a live discussion because I'm looking out from my window and I'm sitting in my home. All right, bankruptcy estate. This is created when the debtor files for bankruptcy. It is comprised of legal and equitable interest of the debtor and can include real property and personal property, such as interest in an LLC, interest in a corporation, intellectual property, and it may include causes of action, appellate rights, and it includes community property, which is also defined in Bankruptcy Code Section 541. Just because certain property is property of the estate doesn't mean that the trustee can administer it. It is subject to exemptions, which will be excluded from what the trustee administers. And you may have already heard, if you're a state court attorney, that there are certain sets of exemptions under California law. California is an opt-out state. There are 2 sets of exemptions that we use under the CCP, 703s and 704s. And this is in line with what Judge Yoon was saying, in that debtors get a fresh start. So they get to exempt or keep certain things, values of certain things. For example, in a primary residence, the debtor can keep anywhere from $75,000 to $175,000 in the home in equity. And vehicles are 58 something. It changes through the years, but debtors get to keep certain things, and it is through the exemptions that they get to keep these things. Next slide.
Hi there, this is Aaron, and we're on the automatic stay, which is one of the creditor's least favorite aspects of a bankruptcy case. Judge Yoon talked about the policy underlying the concept of the bankruptcy process, and the automatic stay is a big part of that. It requires creditors to stop all formal and informal collection activities. The concept is to provide a little breathing space to the debtor so that they can attend to the business of reorganizing their financial affairs. Happily for creditors, it's not an absolute bar. You can seek relief from the automatic stay, and through that process, ideally be able to proceed against your collateral. Sometimes you can negotiate a stipulation for relief from stay in order to allow you to proceed against insurance proceeds or to liquidate a claim without being able to enforce it. But the important aspect for creditors with the automatic stay is you need to be mindful of it, and you need to go in front of the bankruptcy court and obtain permission to proceed. The scary part for creditors is that if you violate the automatic stay, you can really get whammied. Most recently, not most recently, but fairly recently, in the Eastern District of California, Judge Klein whacked the Bank of America for $45 million for intentional violation of the automatic stay. You need to be very careful about these things, and you need to caution your clients when you're representing creditors to, be careful about how they proceed, to get permission from the court, and to confer with you before they take action. Next slide. Next slide here deals with the proof of claim. For people who aren't debtors or aren't frequently involved in the bankruptcy process, the proof of claim form that is attached to the notice of bankruptcy commencement is probably one of your more common interactions with the bankruptcy system. That document is really important from the creditor's perspective, in that that is how you assert a claim against the bankruptcy estate, against the debtor in possession, depending on the context. It's how you do it without violating the automatic stay. And when you file that proof of claim is deemed valid until it is, unless and until it is objected to by the debtor. But the debtor may, in fact, object to it. And then at some point we'll talk about adversary proceedings and whatnot and explain how those disputes over claims are resolved. But there are all kinds of issues that can affect the assertion of a proof of claim. Most importantly, you want to be timely. In connection with the bankruptcy case, they're going to establish what's known as a claim bar date. And if you miss that date for asserting your claim, you can have real problems going forward. Nice judges, like Judge Yoon, will allow nice creditors to get around that if there's a good faith explanation of why you missed that deadline. But you're much better off not having to explain why you missed that deadline. A sort of thing to worry about, or not worry about, to be concerned about, is if you file a proof of claim, you are deemed to have consented to the jurisdiction of the bankruptcy court. And there can be all kinds of strategic reasons that you might not want to do that as a creditor. Moreover, you don't always need to file a proof of claim. So when your client, the debtor who's doing business with your client, files for bankruptcy, you might want to look at the schedules and see if your client has been a scheduled creditor and how that claim is treated, what the amount of it is, if it's disputed, if it's liquidated or illiquid. And those things can govern whether or not you actually want to file a proof of claim. But before you allow a claim bar date to lapse without taking action on behalf of your client, you definitely want to think these things through and consult with your client. Next slide. Man, it's me again. You guys are gonna have heard enough of me in the first 5 minutes of this thing. The adversary proceeding. And really, an adversary proceeding is basically a lawsuit within the bankruptcy court. Now, there's all kinds of wrinkles to that. There's issues. Bankruptcy courts are, in fact, authorized to conduct jury trials under appropriate circumstances. But there's all kinds of issues here. And it's not that every provision of the Code of Civil Procedure applies exactly as it does in district court within the bankruptcy court. You're going to want to look at the rules and make sure you've tracked all of that stuff out. Adversary proceedings can involve not just straight bankruptcy issues, and we'll talk about preferences and fraudulent conveyance claims later, but they can also involve the non-bankruptcy claims, as would be the case with adjudication of the claims that you assert against the debtor. Next slide.
So one of the principles, as you may recall from Judge Yoon's discussion earlier, is the fresh start for an honest debtor. And the way the bankruptcy code achieves this is the section 524A of the code provides for a discharge injunction for individual debtors. So upon getting a discharge, the debts against this debtor are enjoined from being enforced. So it's not that the debts go away, but they are basically enjoined from being able to be pursued. This would apply to any actions against the debtor, as well as any actions against the debtor's community property. So in the case of a husband and wife, if they're both liable for community debts, oftentimes you'll see that only one of the spouse will file bankruptcy and get the discharge that will protect their community property assets. One other just side note is, although I think people often think that corporations get a discharge, they actually do not. But because it's an empty shell after a corporation files a Chapter 7, then there's really no need for discharge and there's really nothing to go after. Next slide, please. Now, there are some exceptions to the discharge, and typically those would involve fraud claims or claims for willful malicious injury or breach of fiduciary duty. Those types of claims can be excluded from the discharge, but you would have to first bring an adversary proceeding before the bankruptcy court to establish that the debt is one of the ones that are permitted to be excluded from the discharge. Next slide, please.
Hi, it's me again. Sorry to slow with my mute button there. And we're going to talk a little bit about preference actions, which are, awesome. They're awesome for debtors. They're awful for creditors. Judge Yoon talked about one of the fundamental purposes of the bankruptcy process being to treat similarly situated creditors similarly. And the preference action is intended to achieve that, much to the distress of creditors who have received potentially preferential payments. The elements are found under 547 of the code, and they appear here in front of you. I think most people are familiar with them. It's a payment to a creditor on behalf of an antecedent debt that was made when the debtor was insolvent. And then there's, limitations on the time, generally 90 days before the filing of the bankruptcy case, but it can be extended to a year for when that payment is made or that transfer is made to an insider. And on that note, it's important to know that it's not just preferential payments that can be challenged under 547, but any sort of preferential transfer. And the timing on that becomes essential. First, a transfer isn't necessarily, like I said, a movement of funds. It can be the recording or perfection of a lien against an asset of the estate. It can be, a transfer of physical property, jewelry, bullion, whatever, and intellectual property, any sort of transfer that takes place within that preference window of 90 days or a year to insiders. The other thing, a couple things to think about when it comes to preferences is that there are, in fact, defenses to them. Most commonly, you're going to deal with ordinary course payments or new value defenses. Ordinary course payments are payments that are made within the ordinary course of business between the non-debtor entity and the debtor. New value is if this entity, when it filed for bankruptcy, owed you money, if you provided value to the debtor after the preferential transfer or allegedly preferential transfer was made, that can give you a defense. The other thing to keep in mind, is there generally a 2-year statute of limitations on the filing or commencement of an adversary proceeding. I'm not going to speak ill of Chapter 7 trustees or debtors generally, but they generally don't do a whole lot of homework. And then all of a sudden this date sneaks up on them. And that's why you frequently find that a whole bunch of these adversary proceedings just get filed without a lot of thought into whether or not these things are actually preferences. And so those lawsuits get filed. More, better Chapter 11 practitioners or trustees like Lay and Linda will send out letters, well before you get to that deadline. But oftentimes it'll kind of slip through the cracks and just get a lawsuit filed again, an adversary action filed against your client, who will then call you in a panic and very upset that they got stuck owing, these people owe me money, and now they're suing to get back the money that they gave me. One of the soothing things you can tell your client is the advice to somebody who's dealing with a debtor who faces potential preference exposure is always the same. Take the damn money. You always take a preference because the overwhelming majority of them are going to settle later, which means at the worst case scenario, you're going to keep some part of it. So if you only learn one thing from today's presentation, it's always take a preference and hope that you can just settle it out or something less. Next slide. You're on mute, I think.
Sorry about that. Next slide is U.S. trustee versus trustee. These are very commonly confused by attorneys who don't practice bankruptcy or practice bankruptcy often. The U.S. trustee oversees a bankruptcy case. Its job is to prevent fraud, dishonesty, overreaching of the bankruptcy system. Its job is to also appoint panel trustees in cases like Chapter 7, Chapter 11, Chapter 13, and now Step 5, and even Chapter 12 sometimes. A trustee, also known as a case trustee, his or her job is very different, and it depends on which chapter you're in. In a Chapter 7, sometimes 11, the trustee, the case trustee, is to usually administers assets or liquidates assets by selling property, operating a business as a going concern, and then selling it. A Chapter 13 case trustee, for example, monitors plan payments. And I think I have another slide later on where I discuss that. So in the Central District, there are about 30 plus panel trustees. And these are the case trustees, which is very different from the U.S. trustees. Next slide. This is
now that we've talked about some big overall concepts in the context of a bankruptcy case, we're going to then spend the next half hour talking about specific types of cases and what could potentially happen in those cases. In the slide that's on the screen right now, it gives you sort of a general background of the primary types of cases that are available to a debtor. Chapter 7 case, as probably most of you know, is liquidation. Individuals and corporations can file. Chapter 11 is generally considered a reorganization, but you can also liquidate. Things get a little confusing, and it's not just for corporations. Individuals can take advantage of Chapter 11. Chapter 13 is only for individuals, reorganization, but there are a lot of limitations on Chapter 13. And we have this new thing called the Small Business Reorganization Act, Subchapter 5 debtor, that only came into effect February of this year, which is another subset of Chapter 11 cases. And the last sort of category of cases, there are others like Chapter 9s and 12, but we're not going to get into that. That's really gets into the weeds of bankruptcy law. The last category is involuntary case, which I think is one of the most dangerous concepts in the bankruptcy law, which I doubt most of you, even experienced bankruptcy attorneys, can go 40 years of their career without ever having done an involuntary. So those are the big categories of cases. And now, once again, I'm going to turn it over to our panel members who are going to really teach you about the law.
So this is just a quick chart on the overviews of the four various types of cases that we're going to focus on, and the differences and similarities between them. Really, I don't know that it requires any time to go through this. You can see it on the screen. But in general, you'll see that Chapter 7s, there'll be a trustee such as Linda who would be appointed to take over the case. There's no trustee automatically appointed in a Chapter 11 case, so the management gets to stay in possession. Chapter 13 and the small business reorganization Chapter 11s have trustees, but these trustees have limited powers. Both 11 and 13s are mechanisms that can allow the debtor to reorganize and pay off their debts over time. Chapter 7 is more of a liquidation chapter where the trustee comes in, sells off the assets, monetizes the assets, and distributes them to creditors. Moving on, next slide.
So what happens when a bankruptcy petition is filed? Well, as I discussed earlier, a bankruptcy estate is created, and as Aaron discussed, the automatic stay is imposed. If you're in a 13 or a 7, there's an automatic appointment of a trustee. If you're in an 11, then the debtor becomes the debtor in possession unless for cause a trustee, an 11 trustee is appointed. Or sometimes, and this has happened where I get appointed in cases where the debtor in possession no longer wants to operate and consents to an appointment. Next slide.
Hi again. So here we wanted to talk a little bit about the priority scheme for repayment of creditors. And again, this is one of those real basic concepts that folks should be aware of. You know, at the top of that waterfall are secured creditors. And so everybody always wants to be a secured creditor in that context. But it's important to realize, right, that secured creditors are only at the top of the heap as to the value of their collateral. And oftentimes there can be big fights in connection with confirmation of a Chapter 11 plan as to what the real value of that collateral is. So even though your client called you and told you that they're, you know, a secured creditor, that they're fully secured, they may find that what they actually are is the holder of a bifurcated claim. That is, it's a secured claim to the extent of the value of their collateral, but they become an unsecured creditor as to the remainder or the deficiency amount. That can be actually important, again, in the Chapter 11 context. If you have a holder of both classes of claim, you can vote in both categories. The second sort of tier on that waterfall is for administrative expenses. Lawyers are very good about making sure that we get paid on these deals, and so we are up at the top, near the top of that waterfall, right? There also can be other things that fall within that administrative priority. People who do business with the debtor post-petition are typically going to be afforded a administrative priority claim to the extent that those services are provided post-petition, and they can, you know, find ways to, well, we'll deal with executory contracts later, but there are other ways to sort of bootstrap into that. Next are priority claims like wages and certain tax claims, and those things are again treated with a preference in that they need to be paid 100 cents on the dollar before anything can flow down to the lowly old, what we call GUCs, that is general unsecured creditors. GUCs are kind of, well, I guess aside from the debtor, they're the lowest person on that totem pole. And oftentimes you'll find, and there's a mention here on the slide, with critical vendors, critical vendor law varies depending on what jurisdiction you're in, but critical vendors can sometimes evade that status as a GUC. Then if at the end of all of this, there is still money to be paid, that value, that cash flows to the debtor. Next slide, please.
I think that's mine. Chapter 7, liquidation cases. So these Chapter 7 liquidation cases come into existence various ways when a debtor files a 7, or if a case is converted from an 11 or a 13, and sometimes Chapter 12. Only individuals get a discharge when they file a 7. And individuals have to be eligible for the 7, to stay in the 7. There's what's called a means test. There are 2 ways to pass a means test, and this is for consumers only and not entities. One way is if the income of the consumer household is less than a certain threshold and is governed by state. If it is not less, if it's higher, then that consumer can complete the rest of the means test and show that there is no disposable income after all of the valid expenses are paid. Typical life of a Chapter 7 case. Usually a trustee is appointed, or every time that a trustee is automatically appointed, and the debtor then has to attend a meeting of creditors, which is set about 45 days out from when the petition is filed. The debtor shows up at these 341A meeting of creditors and testifies under oath about his or her financial affairs, which can include assets, liabilities, income, expenses, and any transfers, etc. If there are no objections to the discharge, then approximately 90 days from the bankruptcy filing, the debtor gets a discharge. So the discharge is very different. It's on a different path than the trustee administration, which, oh, did I say? Oh yeah, that's the second slide. The trustee usually is on a different path when he or she is administering what we call an asset case. He or she would hire counsel or professionals, an auctioneer, brokers to sell real estate, sell businesses. Counsel, he or she can hire general counsel or special counsel, especially for litigation purposes. And it is only after the trustee completes collection of all of the assets or liquidating of all of the assets that the trustee has an accountant file a tax return for the estate. If the IRS fails to audit the estate within 60 days, then the trustee can submit his or her final accounting to the U.S. trustee, which then, if approved, gets submitted to the court and heard, and the final distributions are made at the end of that approval process. Next slide. I think we're doing a poll.
Right, so the poll asks, how many of you will be affected by the recent surge of bankruptcy filings by some of the nation's largest retailers and restaurant chains, such as Pier 1, Soup Plantation, JCPenney, Neiman Marcus, J. Crew?
You know, I was such a frequent shopper at Neiman Marcus, man.
Well, you know, Soup Plantation muffins, I mean, come on.
J. Crew is my place.
Okay, well, we can move on. In terms of a Chapter 11 case, this is often referred to as a reorganization. Clients come to me because their businesses are experiencing cash flow issues, maybe over leveraged. They may want to clean up their balance sheet. They may be in the process of selling their business, and the buyer wants to get a clean bill of sale and get a court order authorizing the sale. And that's a much better way of buying a business and the business's assets with a court order than pretty much any other mechanism. So a Chapter 11 allows a debtor and the debtor's management to stay in possession, to remain in possession of its assets and its operations. And the goal of a Chapter 11 at the end of the case is to propose a plan. The plan could be a plan that would restructure the company's debts and assets and allow the company to stay in business. Or it could be a liquidating plan where the plan proposes to basically sell off the assets and then take the proceeds and distribute the proceeds in accordance with the priority scheme that Aaron discussed earlier. The plan process is one where the plan has to be approved ultimately by the court, but only after creditors are given an opportunity to vote on it. And there are various provisions that the bankruptcy code requires a plan to have. And there are various bases upon which creditors can object to the plan. That's where Aaron gets really happy, is he gets to do a lot of objections and to try to put the kibosh on these wonderful businesses' attempts to restructure and come out of bankruptcy. Like we've discussed many times, unlike a Chapter 7, a trustee is not automatically appointed. This allows debtors management to stay in place. However, a trustee could be appointed if there is a cause to appoint a trustee, and where oftentimes you see there's poor management, mismanagement, or fraudulent management, trustee motion is pretty commonplace. One of the benefits of Chapter 11 are many, but one of the downside of a Chapter 11 is that it is a very complicated and labor-intensive process, and so it can be rather costly in terms of professional fees. It is also fairly demanding of management's time, so we don't usually go into a Chapter 11 without a great deal of discussion, forethought, meeting with management to make sure that there is a viable plan at the end of the day for this business, because otherwise it could just be a very expensive exercise in futility. Next slide, please. Okay. Chapter 11, the life of Chapter 11 case, you'll see, especially in the Delaware cases that get filed in Delaware and New York, there will be dozens of first day motions to approve continuing to make payments to employees and to critical suppliers, motions to allow cash management systems to stay in place, motions to honor customer deposits, motions to establish procedures for reclamation claims. So in these large Chapter 11 cases, if you're representing a creditor, you need to be very vigilant, especially at the very early part of the case, because that's when the debtor's counsel goes in and gets all kinds of motions granted that will govern your creditor client's rights very early on. Shortly after the filing of the case, you'll see a meeting of creditors where the debtor and management will be examined under oath. Creditors are invited to attend and may ask questions of the debtor and management. Many courts will also set a case status conference. The judge will issue a list of questions that they want the debtor to be able to answer and basically discuss with the court where this case is going, where do they see the plan going, and when the plan would be filed. So that's a hearing where a lot of deadlines could be set, including the claims bar date that Aaron mentioned earlier. It is very common to have an official creditors committee appointed by the U.S. Trustee's Office. This tends to be a committee of 3 to 7 or maybe even 9 creditors that are supposed to represent the general interest of all creditors and be sort of provide a oversight of the debtor and the debtor in possession from a creditor's perspective. So as that committee, they are authorized to hire their own attorneys and their own accountants and financial advisors. And so the fees of those professionals are also borne by the debtor and the company. And that is one of the reasons why a Chapter 11 could be cost prohibitive. Chapter 11 debtors are required to file periodic financial reports that are filed with the court. So there's a lot of visibility and transparency in the Chapter 11. So it's actually a good way for creditors to get a lot of information about a company that it normally would not have. Claims bar date gets set usually before the plan is filed so that the debtor has an idea of what kind of claims are out there that it would need to take into consideration in proposing its plan. And then the end of a Chapter 11 is usually the confirmation of a plan to either reorganize or liquidate. This is typically, year or so into the case. It's not something that is simple that can be put together quickly. There's a lot of negotiations usually with creditors of various classes and priorities. It is a lot easier to try to propose and confirm a consensual plan as opposed to fighting with every single creditor. Next slide. So everybody may have heard of this new Small Business Reorganization Act. And Judge Yoon, I believe, mentioned it earlier that it just came into effect in February of this year. It is designed for small business debtors. And that is a debtor that's engaged in commercial or business activities, and their debts do not exceed basically 2.7 million, although under the CARES Act, that debt limit has been raised for a period of 1 year to 7.5 million. Next slide, please. So as a small business debtor, if you make the election to proceed under this act, it's meant to be a case that can move quicker through a Chapter 11 process, and as a result, be cheaper. These cases are just now being filed, and there are still a lot of the Chapter 11 requirements that we discussed earlier, like first day motions. They're still required in these cases. So I think it remains to be seen how much cheaper these cases can be. But there are some benefits of opting for the small business Chapter 11 reorganization, including fewer hurdles in terms of confirming a plan. And but the flip side of that is there is a trustee that is appointed to sort of oversee the process and make sure that the debtor is doing the right thing. The good thing is there is no creditors committee unless the court appoints one upon motion. And so that could be a potential cost saving because you don't have to pay the creditors committee's attorneys and financial consultants. And then the plan basically provides for the debtor to use disposable income to make the plan payments for 3 to 5 years. So there are some unique and beneficial aspects of this. It's, I think, a little too soon to tell how much of a cost savings it will provide, but it is a new option that is available for businesses to try to reorganize, and I expect that this will be heavily tested in the coming months in light of COVID. Next slide, please.
Chapter 13 reorganization case. It's a very small 11. It's available for individuals or individuals who are doing business as various small sole proprietorship. A trustee is automatically appointed. The Chapter 13 trustee's job is to review the plan, provide input regarding plan confirmation, to monitor plan payments, administer payments to creditors. The Chapter 13 allows an individual with disposable income to sort of develop and perform under the plan and repay his or her debts. It's usually used by those who do not or cannot qualify for a 7 or has equity in his or her home that is above the exemption, but then has arrearages in the mortgage that they need to catch up on. Next slide. Life of a Chapter 13 case. Usually a plan is filed. It's a very simple plan. It's a form that's on the court's website. That gets filed when the petition is filed. Then the debtor attends the meeting of creditors, and then the hearing on the confirmation of the plan, assuming that the plan is feasible and is in the best interest of the estate. The plan gets confirmed, and then the debtor makes payments under the plan, and usually the payments are anywhere from 3 to 5 years, and upon completion of the plan, the debtor receives a discharge. Next slide.
Hi there. At the request of David Goodrich, I'm changing my background here. And I get to talk to you about what we in the creditors trade refer to as the dumbest or the worst creditor collection mechanism known to man, and that is the commencement of an involuntary bankruptcy case. You can technically, I guess, file an involuntary 11. I've only been involved with a couple of 7s, and they're just, it's just a bad idea as a general rule. You get all of the expenses and only some tiny percentage of the benefits of forcing this company into it, or an individual, I guess. Generally, you need to have 3 creditors if there are more than 12 unsecured creditors. If they have fewer than 12, I guess you can get out there and be an idiot all by yourself, but it's really a bad idea. The debtor can contest this, and generally does. I mean, I guess you can, I've been in cases where you have an involuntary 7, and then they'll file a voluntary 11 to sort of, you know, end this dispute. But you can have, and I have actually conducted a full-on trial as to whether or not they're insolvency, whether an order for relief should be entered. And if you lose as the petitioning creditor, you get to pay all of their fees. Like I said, it's something to know about, it's something to be aware that it exists. But I'm yet to stumble across a fact pattern where it's a really good idea to commence one. Next slide. Litigating with the debtor, which is candidly kind of my stock in trade. Litigating with the debtor is fun because they generally don't know what they're doing when they get into this context. And there's actually all kinds of advantages for a creditor to properly litigate with the debtor in bankruptcy court. There's all kinds of, you know, in litigation, generally there's all kinds of tactics. But when you get into the bankruptcy context, there's all kinds of things that can be really provide a big assist to you. For one, you know, in a Chapter 7 case, you divest generally the debtor from control over the claim. And so there's an opportunity to settle with somebody who's perhaps a little more rational and a little more objective. The credit that trustee generally accedes to all the rights and privileges of the debtor, which means they are typically the holder of the attorney-client privilege and can create all kinds of opportunities for you to leverage a debtor. You can demand or at least request, you know, a sale of claims. There are also other things that go on in a bankruptcy case that wouldn't ordinarily go on in common litigation or everyday conventional civil litigation. Some of my favorites are fee applications. So you need the debtor, if they want to pay their lawyers, those lawyers need to file fee applications. And if you're a smart litigant on the other side, you can look at those fee applications and see what they're doing and see when they started thinking about this, see when they retained counsel, see when they started talking about retaining counsel. And you can oftentimes figure out the terms under which they retain counsel. You can know if this is a contingency case or not. You can know how much of a retainer they receive. And those things can be really helpful to you in litigating with the debtor. The other thing that you should be aware of is that while you get all of those advantages, there are some disadvantages too. The one that jumps to mind is you and the debtor don't get to decide when the case is over necessarily. Even if you reach a settlement, you have to file a 9019 motion, and Judge Yoon will tell you when and if your litigation is over, and all the other constituencies, with all the other stakeholders will have an opportunity to weigh in on whether or not that settlement should be approved. Next slide, please.
Litigating with plaintiff who files bankruptcy. So if a plaintiff becomes the debtor, the trustee, whether it's an 11 or a 7, becomes the real party in interest, who then represents the interest of the bankruptcy estate and can make all decisions related to the case, including settling and everything related to that litigation. This is very common for me to see, where a debtor who is a plaintiff, usually in a big PI case, fails to either schedule it or mentions it at the 341A. Then a few months later, after the case is filed, I get a call or a letter or an email from the defendant, or sometimes even the debtor, who say, oh, oops, I forgot to schedule this. And the reason for that is because the defendant, who realizes that the debtor is no longer the real party in interest, has filed a motion to dismiss. So that happens quite often. If the debtor is the plaintiff, the automatic stay doesn't apply because it's not a collection against the debtor or property of the estate. So it continues. And in these cases, it's very easy for the trustee to settle because the trustee is a third party or a neutral party and isn't really attached to the lawsuit. And we often do that. Next slide. Or we have a poll. Should I read that? How many of you have litigated against a defendant that has threatened to file bankruptcy in order to leverage a settlement?
So it's not uncommon in the midst of litigation and on the eve of trial to have a defendant claim poverty and the risk of filing bankruptcy. And eventually there are settlement negotiations that take place between the parties to try to resolve the matter without spending the money going through a full-blown trial. If you are looking at documenting a settlement for a client with a party that has already threatened bankruptcy or poverty, might want to just keep in mind as you're documenting that settlement, what would happen if the debtor were to file bankruptcy within 90 days? Could there be a preference argument along the lines of what Aaron mentioned earlier? Of course, take the money, but there are things that you can do, provisions that you can include to perhaps make the implications of a bankruptcy and the potential preference claim less severe than if you gave it absolutely no thought. The other issue is if the claims that you're litigating include fraud claims or breach of fiduciary duty claims, or any of those claims that that would be excluded from the discharge, and the defendant is an individual who may run into bankruptcy court and file a Chapter 7 or 13, you might want to, you would be well advised to make sure that whatever findings you get in state court are detailed and that they would support res judicata or collateral estoppel, not res judicata, but collateral estoppel, so that you can use those findings and conclusions in the bankruptcy adversary proceeding if and when the defendant runs into bankruptcy to try to get a discharge, so that you don't have to relitigate all of the issues that you've already litigated once in state court. But if you end up with a state court judgment that just says fraud with absolutely no findings, then that would be very difficult to apply collateral estoppel to. And so most likely in that case, you would have to relitigate the fraud claim to try to get it excluded from the discharge in the bankruptcy court. So clients are not particularly happy about paying legal bills and would probably be pretty upset if they had to pay it twice. And then one other thing is, as we've discussed many times, the automatic stay does apply to all civil litigation matters upon bankruptcy filing, including appeals that are filed by the defendant. So just something to keep in mind so that you don't run afoul of the automatic stay when there is a filing. Next slide, please.
Hey again, and much to Mr. Goodrich's chagrin, I got rid of the Tiger King background. But when it comes to doing business with an actual or potential debtor, doing business with an actual debtor is not all bad. As noted before, you're generally afforded an administrative priority claim, which means you're gonna get paid 100 cents on the dollar before the gucks get anything. So that can be a good thing. The really scary bit, and the thing that's not so good, is when you're dealing with somebody who's potentially a debtor or is in what we sometimes refer to as sort of the zone of insolvency. When that happens, you need to be careful about making sure that you don't end up having preference exposure. You want to make sure you don't have fraudulent conveyance exposure. You want to make sure that you get to keep everything that you get paid, and that you stay on top of and manage that relationship. That's why in sophisticated regulated industries, I'm thinking like aerospace and defense, built into those contracts are all kinds of financial reporting provisions that allow them to monitor the progress of and status of the contracting party. One of the things that people don't always think about is making sure that you get paid by the right person. If you get, it's not uncommon, right, when people are slow to pay, my uncle's going to pay you, or they write a check out of a different account. Those sorts of things are the situations from which fraudulent conveyance claims emerge. And there are other things that you can do in managing your risk when dealing with somebody who's sort of in that zone of insolvency, if you will. You can build into the contract restrictions on the transfer of that contract. Now, query how effective that's ultimately going to be. But if you build into it objective necessary qualifications for their performance under the contract or any other assignee, that can give you an argument to at least make in the context of negotiating over an assignment, an assumption and assignment of that contract to a third party. And the other things you can do is build in defaults that will be difficult or impossible to cure. So that again, query how effective that's going to be if it really comes down to push versus shove in front of the bankruptcy judge. But it gives you negotiating leverage in the context of working through issues with the debtor after they file. Next slide, please.
Well, let me begin by saying I am amazed we got through all these PowerPoint decks during our preparations. I didn't think we were going to be able to get through all of these, but it's quite amazing. So the parting thought here, for those of you who don't generally practice bankruptcy law or who only occasionally practice bankruptcy law, I hope this program was helpful, that you learned something. But as a bankruptcy judge, the advice I would give, and I think all the panelists as practicing attorneys and trustees would agree, bankruptcy is tricky, it's difficult. For the most part, bankruptcy law is like a superstructure that imposes itself on existing law and trumps existing law, but sometimes it doesn't. And all of the panelists got a question from one of the participants that I think really highlights how tricky these things get. The question was, is a debt owed to a military hospital being collected by the U.S. Department of Treasury dischargeable? The answer is generally a unpaid hospital bill is dischargeable. I don't know the answer off the top of my head, but an experienced bankruptcy attorney, if I was asked that question, would also tell you, the federal government oftentimes builds into non-bankruptcy law certain rights that other creditors don't have. And two, there's this concept called recoupment. Recoupment exists outside of bankruptcy. It is a bizarre, one of those bizarre areas of law that bankruptcy law as a superstructure doesn't trump it. Existing recoupment law that exists outside of bankruptcy trumps the bankruptcy law. Automatic stay doesn't apply, for example. And it's almost immaterial whether the debt's discharged or not. The federal government can recoup a debt that a debtor owes if from other monies the federal government owes the debtor. So even though I don't know the answer off the top of my head, an experienced bankruptcy attorney will know, well, this is not an easy answer to that question. We have to look at a couple of other areas of the law to come up with the right answer. So I think that question is I'm actually glad somebody asked it, because it's a great example of how complicated, how nuanced bankruptcy law can be. We have now, this is a 1 hour program. We have now passed the 1 hour, but before I end, I did want to ask Linda, because another participant asked a question. In an individual case, as a Chapter 7 trustee, in an individual case, the intake forms a consumer debtor lawyer takes from an individual debtor, who does that belong to? Does it still belong to the debtor's attorney under that attorney-client privilege, or does that now belong to the trustee? I know in the context of corporate case, there is an old 9th Circuit case law that says no, trustee steps into the shoes of the debtor, including the attorney-client privilege. I think the general consensus, I'm not aware of a definitive, circuit level authority that in an individual bankruptcy case, the individual debtor's attorney-client privilege with the attorney still trumps the trustee's right to consider that part of the bankruptcy estate. But we'll end with, I don't know, I'm naturally deferring to Linda because she's a Chapter 7 trustee, but if other panel members want to chime in as well, go ahead.
And I agree with you that the attorney-client privilege usually that I can waive is that of a corporation. But I think it goes beyond that. It depends on what's in that information. In the intake forms, I may ask if it relates to the debtor's assets that I'm investigating. I may ask to see a copy of that. And I don't know if the attorney says, well, it's attorney-client privilege. I may find other ways to investigate why the attorney is asserting that, because a potential malpractice claim could belong to the estate to the extent that the damages can be attributed to the estate. So it isn't in the inquiry if the attorney who represents the debtor says, oh, I'm not turning those over to you because it's covered by the attorney-client privilege.
Aaron or Lele, you want to chime in on that issue?
I think you would be able to get access to those things. I think, case law, at least in California, is pretty clear that file belongs to the client. And to the extent that you exceed the rights of the client, I don't know that you could make him or her actually give you the file, but I think you would certainly be allowed to inspect it. I think that's a pretty fundamental right at least under California law, and you'd be able to see those things. And I could see how there could be a giant fight on it, because I could see how that could be a really important thing to figure out what that debtor did or didn't tell its lawyer.
Yeah, for our business clients, when we do the engagement letter, we will put in the letter to advise them that if they file Chapter 11 and a trustee were to be appointed, the trustee would succeed to the attorney-client privilege, just so they're not surprised down the road and we're turning over a bunch of files.
Great. Well, I want to thank all the panelists for preparing and doing this program. We are now like 6 minutes past the hour. I think we've overstayed our welcome on this Zoom webinar. I want to thank all the participants for signing up for this program. And that ends our little webinar program. Thank you, everyone.
Thank you.
Thank you. Bye. Take care.